All right, we're back after a short break. Our last case of the day, which is GN 23001964. It's an unusual party to have in my court. It's the Kingdom of Sweden versus Riza Azari. We're hearing a motion for summary judgment. This motion was set by Mr.
Bynum.
Douglas Bynum, Mr. Bynum. And Mr. Azari, you're self-represented, is that correct, sir?
Yes, Your Honor.
Okay, that's no problem. All right, Mr. Bynum, you may proceed.
Yes, Your Honor. We are here today on a motion plaintiff, Kingdom of Sweden's motion for summary judgment on a breach of contract claim. As the motion and the declarations attached to it show, there was a claim against Mr. Azari for failure to repay student loans. Beginning in February of 2002, defendant Mr. Azari submitted multiple applications in which defendant agreed to repay student loans. The plaintiff granted the applications and notified Mr. Azari that he would receive the study aid pursuant to the terms of the applications, the repayment regulations, and the decisions, all of which are attached to the motion. There was a contractual relationship was formed between Mr. Azari and plaintiff. Plaintiff loaned a total of 643,179 Swedish crowns. We have used the exchange rate on the day that the motion was filed to 62,899 US dollars. Mr. Azari breached this contract by failing to repay the amounts. Per the contract, defendant's breach caused injury to the plaintiff by failing to repay those amounts. The amounts are supported by a declaration, two declarations from individuals with knowledge of Mr. Azari's account and how notices are sent out and how the loans are sent out, and a ledger of the payments that were of the notices of amounts due and the failure to make payment. Mr. Azari has not filed a response to this. So the absence of establishing fact issues, we believe plaintiff is entitled to the summary judgment as a matter of law, as the motions show that there's no genuine issue of material fact in this matter.
All right, thank you, Mr. Bynum. Mr. Azari, what Mr. Bynum is saying is that you haven't filed a response, and such is necessary when you are facing a summary judgment. But nonetheless, I will allow you certainly to speak on your own behalf. You may proceed.
Thank you for your time, Your Honor. I did receive a small student loan when I attended UTSA back in 2002. I was served by Cook, Keith, and Davis on September 4th at my house. And prior to that, I had not received a single notice. I have a dual citizenship, U.S. citizenship and also Swedish citizenship. That being said, I received, they knocked on my door and served me with paper. I did take the documentation and visited with a couple of different local councils that in Austin. None of the councils could really help me because what they relate to me was they're not familiar with a case like this, and also they did not believe that Cook and Keith and Davis had a case. I did not. The balance they're referring to is outrageous. What they were telling me was, hey, pay us $63,000 or we're gonna file a lien on you. I mean, there were again 20 plus years has gone by, not a single certified letter, not a single notice, nothing. Next, my wife was shocked. They knock on my house, they serve me with paper, and I just don't judge. Your Honor, be frankly honest. I just don't know how to go about this because the amount they're claiming is outrageous. They did not lend me $60,000. That's for fact. And some of this documentation from 20 years ago, I don't even recognize. that you're claiming that I signed off. I mean, what is the statute of limitation on this? And, you know, I don't want to say that I was harassed by Cook, Keith, and Davis, but they were, since they served me, they were being very aggressive in that regards. And I talked to, and Mr. Biden knows, I did have a counsel that kind of helped me look through this paperwork. And he said, look, Mr. Azari, I cannot point you in the right direction because this is, he stated that he believes that they don't have a case because of their laws here, and he was not familiar with this Kingdom of Sweden filing this.
All right, so let me ask you, Mr. Azari, you said you took out a student loan to go to UTSA. Did the Swedish government loan you money go to UTSA?
It was a grant. That was what my understanding was. It was a small grant for me to come here to first semester, not a student loan. That was my understanding back in 2000 when we first, when we first started, I guess, the dialogue. Mm-hmm. And it was for 2 semesters, I believe. I believe they gave me one grant, which was, a few $1,000s. It wasn't $62,000.
No, because why it's so much is because they're going to say it's because there's interest on it, right? I mean, this is a long time ago, and of course, if you borrow money and you don't pay it back, it gets interest accrued. I think that's where that big number comes from. I could be wrong. I don't know. I mean, obviously, this is your life, not mine. So, sure. All right. So, Mr. Bynum, why is it that this isn't barred by the statute of limitations in Sweden?
Your Honor, I have that. It is in the. I'll just read from here in the motion for summary judgment. Exhibit D shows the Swedish law that increased the statute of limitations to $25,000. To 25 years for the recovery of unpaid student loans. It also states, in Exhibit E, the Swedish Study Support Act shows that the student loans become barred 25 years after it was made unless the limitation is disrupted prior thereto. A disruption of the statute of limitations under Swedish law is when a notice letter is sent to the debtor. Now, the affidavit, the declarations attached here to by the representatives from the Kingdom of Sweden will show that demand letters and notice letters were sent to Mr. Azari numerous times per year. And the judgment of its Administrative Court of Appeal in Goat Board, which is Exhibit H, states that a debtor shall be considered to have received demand letters when several such mailings have been sent to the debtor's Swedish registered address. If Mr. Azari never changed that address regarding these loan applications, then the only address they have is that one. That meets their requirement as far as notice to Mr. Azari.
Okay. So the amount that we're talking about here, he's saying he's recalling a small loan, which he thought was a grant back in 2002.
It was a grant. It was not a loan. And, going back to the Swedish Supreme Court, it's on your documentation, Mr. Bynum's, it does state that if they trying to contact me for 4 years and have no further luck, that they could not be entitled. I mean, you just stated, Doug, you just stated, Mr. Bynum, that they had sent me several notices. Can you please tell me number one, what address you're referring to? And also, did they send a certified letter that anyone on my behalf or myself signed that I could have received the notice? And then you show up 22 years later.
Stop.
I'm sorry.
Summary judgment is denied. This needs a hearing. Okay, so it's denied. You can appeal it if you want to, but this is denied.
I need a hearing over what? I'm sorry.
Oh, you're going to need a hearing. I need to have this gentleman come in and talk about why he feels like he didn't get notices on it.
Your Honor, I would like to make one more request, and this is like, Mr. Azari had an attorney. He let him go. He chose to represent himself. He agreed to this motion for summary judgment. We issued our summary judgment. We filed our motion. He had adequate time. At no point is he presented any evidence or argument or claiming that these isn't correct. And now he's coming in here today to try to present evidence that should not be allowed.
Yeah.
And this is the first of any of his arguments we're hearing.
Well, very good. So I'm going to deny it. You can file a motion for a hearing if you want to, but right now this is denied. I just cannot. We've got a Kingdom of Sweden versus Mr. Azari. And Mr. Azari is saying he went to UTSA a little bit in the early 2000s, and now he's owing $62,000. I just feel like this is the type of thing that needs to go to a hearing, just a bench hearing to make a decision rather than on summary judgment. So nope, stop arguing with me. I will draft the order. The summary judgment is denied. If you don't like it, follow the rules on an appeal. All right. Thank you all. You may be excused.
Thank you, Judge. Thank you, Honor.